Okay. Thank you everyone for joining us today. My name is Diana Padierna and I'm the Executive Director at Landlord Self-Help Center. We're excited to conclude our Landlord Lunch and Learn series. Before we begin, I would like to go over a few housekeeping items. This webinar is being recorded and the recording will be available on the Landlord Self-Help Center website if you would like to watch it again later. The question and answer feature is enabled, and you're welcome to submit questions related to today's presentation. These questions will be addressed during the question and answer segment at the end of the presentation. Please note that our presenters will only answer questions related to the presentation, which is understanding the N5. If you have questions about your specific situation, we encourage you to contact our office during business hours. Finally, a reminder that the information provided during this presentation is intended as general information and does not constitute legal advice. All right, let's get started.
All right. Hello and welcome to the Landlord Self-Help Center's Lunch and Learn session. My name is Ashley, and I am a community legal worker and paralegal. My colleague Catherine is also going to be presenting today. The Landlord Self-Help Center is a community legal clinic funded by Legal Aid Ontario. It was founded in 1975 and incorporated in 1977. The Landlord Self-Help Center has a province-wide mandate to support the small-scale landlord community. Approximately 80% of our resources are dedicated to direct client services. This Lunch and Learn session is the third and final of this year's Lunch and Learn series, and will focus on understanding the N5. This presentation will be made available for replay on our website along with past presentations. At the end of the presentation, as Diana mentioned, we will be having a question and answer period. You can use the Zoom functions found at the bottom of your screen to ask your questions. Please note, information provided in this presentation is intended as general information and is not legal advice. At the Landlord Self-Help Center, we acknowledge the land we are meeting on is the traditional territory of many nations, including the Mississaugas of the Credit, the Anishinaabe, the Chippewa, the Haudenosaunee, and the Wendat peoples, and is now home to many diverse First Nations, Inuit, and Métis peoples. We also acknowledge that Toronto is covered by Treaty 13 with the Mississaugas of the Credit and the Williams Treaties, signed with multiple Mississaugas and Chippewa bands. As a community legal clinic funded by Legal Aid Ontario with a private province-wide mandate, we acknowledge that there are 46 treaties and other agreements that cover the territory now called Ontario, and we make this acknowledgement in support of the necessary work of reconciliation. Residential Tenancies Act was created in 2006 and is the Ontario legislation that governs most residential tenancies and matters related to renting in the province. The Residential Tenancies Act is commonly referred to as the RTA. The RTA establishes laws for landlord and tenant obligations, rent increases, and provides the grounds for termination of tenancies. In order to terminate a tenancy protected under the RTA, you must have a valid reason. The RTA sets out the following reasons to terminate a tenancy: non-payment of rent, damages, interference with enjoyment, own use, persistently late rent, demolition, repair, or conversion. Today, we will be focusing on the N5 notice, which is a notice to end your tenancy for interfering with others, damage, or overcrowding.
What is the N5 notice? As Ashley just explained, the Residential Tenancies Act outlines what is considered a valid reason to end a tenancy. The N5 notice is the first step if you're trying to terminate your tenant because your tenant has interfered with your or another tenant's reasonable enjoyment of the rental complex and/or lawful rights, privileges, or interests. If your tenant has caused damage, or if there's overcrowding in your tenant's unit. The N5 is a voidable notice, meaning the tenant has 7 days to correct the behavior and avoid eviction. If the tenant does correct the behavior, the first N5 essentially becomes a warning letter, and the landlord cannot proceed with the eviction. However, if the tenant misbehaves again within 6 months, the landlord can serve a second N5. Ashley will explain in greater detail later in this presentation the steps to follow after serving the first N5 versus the second N5. But first, I'm going to explain in depth the different reasons to use this eviction notice. Reason number 1, interference. The tenant's behavior or the behavior of someone living or visiting with the tenant has substantially interfered with another tenant or the landlord's reasonable enjoyment of the rental complex and/or lawful rights, privileges, or interests. But what does that really mean? To determine if your tenant is substantially interfering, the following 3 sections of the Residential Tenancies Act should be taken into consideration. Section 33, the tenant is responsible for ordinary cleanliness of the rental unit except to the extent that the tenancy agreement requires the landlord to clean it. Section 36, a tenant shall not harass, obstruct, coerce, threaten, or interfere with the landlord. Section 64, subsection 1, a landlord may give a tenant notice of termination of the tenancy if the conduct of the tenant, if the conduct of the tenant, another occupant of the rental unit, or a person permitted in the residential complex by the tenant is such that is substantially interfering with the reasonable enjoyment of the residential complex for all usual purposes by the landlord or another tenant, or substantially interferes with another lawful right, privilege, or interest of the landlord or another tenant. So, interference when it's reasonable enjoyment. Interference with reasonable enjoyment is relatively straightforward. If your tenant is doing something that is bothering the enjoyment of other people living in the rental complex or interfering with yourself, it's an interference with reasonable enjoyment. Common examples of interference could be smoking inside, rather because it is not permitted in the lease or because it is causing significant interference with other tenants or damaging the rental unit. Later, I'm going to present a case about smoking that was considered substantial interference. Another example is excessive noise. Now, there is a difference between a couple who hosts a few friends over to watch the Leafs finally win the Stanley Cup and the neighbors get upset over the cheers, versus a couple who consistently has loud fights at 3 o'clock in the morning. The noise itself needs to be unreasonable and reoccurring. Misuse of common areas. This could be someone using the common laundry room as their own personal storage, or someone who overuses a shared backyard to the extent that other tenants or the landlord cannot reasonably enjoy the space. For safety issues, this is where the concern of safety is something that warrants the opportunity or to be corrected. For example, someone is blocking an exit with their personal items, which is a fire concern, but those items could easily be removed. Last, unwanted behavior. I've put an asterisk besides unwanted behavior. Landlords should be cautious that every situation is different. Unwanted behavior needs to be a situation that could be considered harassment, obstruction, coercion, or threatening, and must be substantial to the point that they're interfering with the landlord or another tenant. In other words, unwanted behavior can be quite subjective. Our self-help tip is to know that there are different notices for things like safety and illegal activity. So make sure you're using the right notice, and if you're unsure, seek legal advice. Moving on to interference when it's lawful rights, privileges, or interests. Interference with lawful rights, privileges, or interests is a little bit more complicated. Some landlord's rights are established under the Residential Tenancies Act, where others can be established in lease agreements. Some examples of interfering with lawful rights, privileges, or interests include the tenant failing or refusing to prevent, the tenant refusing or preventing entry into the unit, the tenant failing to obtain tenant's insurance if the lease requires it, the tenant failing to pay utilities, also if the lease requires it, failing to maintain the unit to a standard of ordinary cleanliness, or interfering with the landlord's rights to sell the property. Landlords should be mindful that if the lease agreement contracts out of the Residential Tenancies Act and your tenant is violating that lease term, your N5 will not be successful. An example of this is a lease term stating a tenant is not allowed to have overnight guests or pets. Because overnight guests and pets are allowed under the Residential Tenancies Act, it is not an interference, unless those guests or pets are causing damage or preventing reasonable enjoyment or posing a safety concern. Moving on to reason 2, damage. The tenant or someone visiting or living with the tenant has willfully or negligently damaged the rental unit or rental complex. To void the notice, the tenant has the options to repair the damaged property, pay the amount of how much the estimate cost is to repair the damaged property, replace the damaged property if it is not reasonable to repair, or pay the amount of how much it would cost to replace the damaged property if it is not reasonable to repair. But what is considered damage? It is important to understand that under the Residential Tenancies Act, Section 20, subsection 1 states, a landlord is responsible for providing and maintaining a residential complex, including the rental unit in it, in a good state of repair and fit for habitation and for complying with health, safety, housing, and maintenance standards. Whereas Section 30(4) states, the tenant is responsible for the repair of undue damage to the rental unit or residential complex caused by the willful or negligent conduct of the tenant, another occupant of the rental unit, or a person permitted in the residential complex by the tenant. In other words, normal wear and tear is the responsibility of the landlord. But what is normal wear and tear? Normal wear and tear is defined in Cambu versus Brampton Caledon Housing Corp., which is a case often cited in LTB orders as an unavoidable deterioration in the dwelling and its fixtures resulting from normal use. Within this decision, Judge Clean gives the example that carpet wear due to normal traffic is wear and tear, while a cigarette burn in carpet is avoidable and constitutes damage. Within the decision, Judge Clean mentions the definition of wear and tear stated in Haskell versus Merrow, which is a case dating all the way back to 1928. That case states, reasonable wear and tear means the reasonable use of the house by a tenant and the ordinary operation of natural forces. Landlords should be mindful that the length of the tenancy will be taken into consideration. The longer the tenancy has gone on for, the more likely there will be wear and tear. Later in this presentation, I will discuss a case regarding the difference between wear and tear versus damages. So, assessing damage. Before serving an N5, a landlord should ask themselves the following. First, what is damage? Ideally, landlords should perform inspections and have pictures of the damage. Next, did the tenant cause this damage willfully or neglectfully, and can you prove it? The onus will be on the landlord to prove on a balance of probabilities that a tenant caused the damage willfully or neglectfully? And last, how can a landlord determine the cost? Our self-help tip, landlords should get 2 quotes for replacement or repair costs and then choose the least expensive one. For the last reason, reason 3 is overcrowding. There are more people in the rental unit than is permitted by health, safety, or housing standards. Under the Residential Tenancies Act, there is no definition of overcrowding, so landlords must look to their local bylaws to determine if there are more people living in the rental unit that is permitted by health, safety, and housing standards. Overcrowding is often defined in the bylaws under occupancy standards. Most will outline things like wall size requirements, ceiling height, or windows. For the purposes of determining overcrowding, you must look at the per person square meter ratio. I'm going to provide some examples. The Toronto overcrowding bylaw states, for rooms used by only one person, the minimum floor area of the room used for sleeping shall be 6 meters square, which is approximately 65 square feet. Whereas rooms used by 2 or more persons, the minimum floor area of a room used for sleeping shall be 4 meters squared, which is approximately 42 square feet for each person. The maximum number of persons living in a habitable room cannot exceed 1 person for each 9 square meters of habitable room floor area. To look more into this, you can follow the source link at the bottom of the slide. Second example is Brampton. Where a bedroom is provided to 3 occupants, there must be a minimum floor area of 14 meters squared, which is approximately 150 square feet. This requirement aligns closely with the Ontario Building Code for rooms such as university dormitories. Where a bedroom is provided for 4 or more occupants, there must be a minimum floor area of 7 meters per square foot, or 7 meters squared, which is about 75 square feet per occupant. Additionally, no person shall be permitted to occupy for sleeping purposes any cellar or space used as a lobby, hallway, closet, bathroom, laundry, stairway, kitchen, accessory building, or shed unless otherwise permitted. Again, for more information, I have the link at the bottom of the slide. Our last example is Ottawa, where the maximum number of residents in a dwelling unit shall not exceed 1 person per 9.3 meters squared, which is approximately 100 square foot of habitable room floor area. It's important to understand that for the habitable space, not sleeping space, children under 12 years of age are deemed as a half person. The minimum floor area of a room in a dwelling unit used by 2 people or more for sleeping shall be 3.7 meters squared, which is approximately 400 square feet for each person using the room. Again, there is a link provided on the slide.
Okay, now we're going to discuss how to fill in the N5. On the screen, you will see an example of an N5. When filling out an N5 notice, it is very important to follow the instructions and to ensure that you have filled out all of the correct information. Errors on a notice can lead to the dismissal of an application. Names. Under the tenant's name, you should include tenants listed on the lease agreement. You would not include minor children or occupants or guests of the tenant. Under the landlord's name, you can include the name of all of the landlords. Under the address, it is important to list the full rental unit address. For example, if someone is renting a basement unit, you would need to identify the unit as basement on the notice. The same applies if they are renting a room. The room should be clearly identified and labeled under the address of the rental unit. The termination date will vary depending on if it is a first N5 or a second N5. We will go into further detail about the specific termination dates later on in the presentation. In this example, we are selecting reason 1. Your behavior or the behavior of someone visiting or living with you has substantially interfered with another tenant's or my reasonable enjoyment of the residential complex and or lawful rights, privileges, or interests. We've also selected that they have 7 days to correct the behavior described on page 2 and avoid eviction. Under details on the N5, it is very important to include specific dates, times, and particulars of the events being alleged. We recommend attaching a Schedule A so you can fit in all of the relevant information. On the notice itself, you would type in, "Please see attached Schedule A." Ball versus Metro Capital Property is a divisional court case which states, in reviewing the sufficiency of the details in a Form N5, it is necessary to consider the context of the notice. There are several purposes for requiring the landlord to provide the reasons and details. This is a leading case, and it states that all notices must have sufficient details. Your N5 should clearly state the particular details of each incident that you are alleging. The case also states the tenant needs to know the specific allegations against them in order to be in a position to know the case that must be met, to decide whether to dispute the allegations made against them before the tribunal, or to consider whether to stop the conduct or activity or correct the omission within 7 days and thereby void the notice. Particulars should include dates and times of the alleged offensive conduct together with a detailed description of the alleged conduct engaged in by the tenant. On this slide, you can see a perfect example of insufficient particulars. The date range lists from March to October with no specific year, and the details of the events is landlord was denied entry for inspection. This does not explain what the tenant did or how to correct the behavior. Therefore, it is insufficient. On this example, as you can see, there are specific dates and times. For example, the first one lists September 30th, 2025 at 3 a.m. The allegations describe what the tenant has done, and at the bottom it lists what the tenant can do to correct the behavior. In this example, it would be to stop having parties that include loud yelling and breaking of beer bottles. Once you have filled out the N5 sufficiently, next you will need to serve it. The certificate of service sets out the various methods of service that we will discuss next. It is important for landlords to remember that if you're going to serve a notice by email, you must have consent to email service in writing or under Section 3 of the Ontario Standard Form of Lease or on the Landlord and Tenant Board form called Consent to Service by Email. General communication does not mean that you have consent to email service. You should keep in mind that if you serve a notice via email to your tenant, the Landlord and Tenant Board will likely ask you to provide proof of the written consent for email service at the hearing. An example from the standard form of lease shows that there is consent to serve via email service, and it has the tenant's email and the landlord's email listed very clearly. On this example of a certificate of service, you can see the rental unit address has been filled out in completion. It says I, Travis Brown, which is the name of the landlord, certify that on October 8th, 2025, a notice of termination form N5 was served, and they served it to the following persons: the tenant, Joanna Smith. On this section of the certificate of service, It details the various methods to serve to your tenant. In this example, we have handed the documents to the persons. Other valid methods include handing the documents to an adult person in the tenant's rental unit, leaving the documents in the mailbox or place where mail is normally delivered, placing the documents under the door of the rental unit or through a mail slot in the door, sending the documents by courier to the persons, sending the documents by fax to a fax number. You can also send the documents by regular mail by adding 5 days to your termination date. It is very important to note any mail strikes or discontinuances with the mail during the period that you're going to serve. If there is a mail strike, we would not advise serving via this method. As you can see, this is the last part of a certificate of service. The person who actually served the notice to the tenant would sign this. In this case, it was the landlord. He has his first and last name, his telephone number, and the date, and he would also sign the certificate of service, advising that everything in there is true and correct. So the first N5. A first N5 should be served when a tenant has interfered, caused damages, or has caused overcrowding issues. An N5 is considered the first N5 if you are giving your tenant an N5 for the first time, or you served a previous N5 more than 6 months ago. A termination date on a first N5 is 20 days, and the voidable period for the tenant to correct the behavior is 7 days. Voidable period. A first N5 has a voidable period of 7 days. This means that once the tenant has been served with the notice, they have 7 days to correct the behaviors and void the notice. If a notice has been voided in the 7-day period, you would be unable to proceed with filing an L2 application. A landlord must keep proof that a tenant did not void the notice in the 7-day period. For example, if your notice is about a tenant preventing entry, a landlord should serve another notice of entry and try to enter the rental unit again within the 7-day void period. A landlord should be keeping a log of any issues or incidents that occur during this 7-day period. Catherine will be referencing case law later on that describes what happens if a landlord does not have sufficient evidence of what occurred during the 7-day period. Proof can include a log of complaints from other tenants, a log kept by the landlord, emails, text messages, photographs, or videos. If a tenant has not corrected the behaviors within a 7-day period, the landlord can then proceed to file an L2 application, which is an application to end a tenancy and evict a tenant or collect money with the landlord and tenant board. A second N5. You would serve a second N5 if a tenant has voided a first N5 within the 7-day period, but starts up the behaviors again within a 6-month period after receiving the first N5. The termination date on a second N5 is 14 days. There is no voidable period on a second N5. Once it has been served to the tenant properly, a landlord can then file an L2 application with the landlord and tenant board. When filing with the board, a landlord should make sure that they're also including a certificate of service and a copy of their first N5. The L2 application, as I mentioned, it is an application to end a tenancy and evict a tenant or collect money. It can be filed online via the Landlord and Tenant Board Tribunal's portal, Tribunal Ontario portal. You can also file it in person at certain Service Ontario locations. If you are filling out an L2 application, the Landlord Self-Help Center has a Landlord Learning module that can assist you. You can find the module on our website, which is landlordselfhelp.com/landlord learning modules. The fee for filing can be found on the Tribunal's Ontario website. After filing an L2 application, the Landlord and Tenant Board will schedule a hearing date and send out a notice of hearing to both parties. Evidence is due 7 days or more before the hearing. A landlord should serve the evidence to both the Landlord and Tenant Board, which can be uploaded via the Tribunal's Ontario portal or by email, and to the tenant. For the submission and format of evidence, the Landlord and Tenant Board practice direction states all documents, photographs, and other items provided to the other parties and the LTB as evidence must be readable, have consecutively numbered pages, and include a list or table of contents identifying each item in order and by page number if more than one item is being submitted.
Okay. Moving on to the last portion of our presentation, where I'm going to introduce some case law that discusses where N5 notices were served. So the first being Hain versus Minto Apartment Limited Partnership. This is a landlord's application in front of the Landlord-Tenant Board to evict a tenant because of substantial interference on other tenants caused by the tenant's heavy smoking. The tenant had lived in the rental unit for almost 40 years. While the apartment building had a no smoking policy, the tenant's lease was unique in that it permitted smoking because this tenant had been grandfathered in from previous owners. The tenant did not dispute smoking in the unit and admitted that he smoked 1.5 packs a day. Before issuing an N5 notice, the landlord had issued several warning letters. The tenant would receive a letter and smoke outside for a day or two and then go back to smoking inside. The landlord's property manager testified about the building common ventilation system, which was working properly and circulated fresh air through the front doors of the units. He testified that the tenant's unit was visibly stained, possibly from the tenant's heavy smoking, and that there were no other smokers on the tenant's floor. Finally, he testified to the landlord's efforts to minimize the impact of smoking by sealing units and providing air purifiers, and that he did not believe there were any further steps the landlord could take to resolve the smoke issue. The tenant's neighbor also testified for the landlord that she had lived in her unit for 4 years and was seriously impacted by the smoke. She had asthma and sometimes became nauseous from the smoke smell. She testified that when the tenant received a warning letter, he would smoke on the balcony for 2 or 3 days and then return to go smoking back inside his unit. The tenant had not made any meaningful attempts to address the impact of his smoking and even refused the use of an air purifier in his unit. During cross-examination, the tenant stated that he intended to live his life. Ultimately, because the adjudicator did not believe that he would comply with a conditional order, an eviction was granted. Due to his long tenancy, it was delayed by 7 weeks. Also, it's important to note that the tenant had filed a request to review this order with the Landlord-Tenant Board, which was denied. The tenant then attempted to appeal to divisional court, where the eviction was upheld. The next case, Sigma Canada Inc. versus Tenant. This was a landlord's application to evict a tenant because the tenant or someone the tenant permitted in the residential complex had willfully or negligently caused damage to the premise. As a preliminary issue, the tenant's representative provided that the N5 did not comply with the requirements laid out in Ball versus Metro Capital Property, which was the case Ashley previously discussed. The adjudicator, however, did find that the notice was sufficiently detailed. The landlord was alleging damage to the floors, walls, kitchen tiles, countertop, drains, and appliances. The tenants had been residing in the unit since 2013, so roughly 12 years. During the hearing, the landlord presented photos from an inspection that showed a cluttered unit in need of cleaning, but did not submit any photographs of the rental unit before the tenant had moved in to the rental unit to establish the condition of the unit prior to their tenancy. Additionally, the landlord could not confirm when the floors were last refinished or if any fixture, for example, the bathtubs, faucets, countertops, had ever been replaced, or the age of the plumbing, the faucets, the bathtub, the oven, or the counters. The adjudicator found that there was no evidence to prove that a tenant or tenant's guest had caused this damage, or that the damage could have been caused negligently. As such, this application was dismissed, stating that any damage was simply just actually wear and tear. The last case, TSL 86439, is a review from the Landlord Tenant Board held in 2017. This is an landlord application to evict the tenant because they, another occupant of the rental unit, or someone they permitted in the residential complex had substantially interfered with the reasonable enjoyment or lawful right, privilege, or interest of the landlord or another tenant. The hearing was first heard uncontested, and the landlord was successful at receiving eviction. However, the tenant filed a request to review on the basis of being unable to participate. That review was granted by the Landlord Tenant Board. During the review hearing, the alleged conduct included smoking tobacco and other substances in the rental unit, causing loud noises, loud arguments, sexual activities in the common laundry room, blocking a tenant from entering the laundry room, and engaging in sexual approach towards that tenant. Various incidences were cited on the N5, which was served to the tenant on July 20th. Both the landlord and the adjudicator understood that the voiding period was July 21st through to July 27th. Through the landlord's witness, which was another tenant, a log of incidences dating from May 14th, 2017 to September 26, 2017 was entered as evidence. However, the document contained no reference whatsoever to any offensive conduct occurring anywhere near the notice period other than smelling smoke on July 25th and July 26th. The tenant testified that he does not smoke in his unit, and other tenants in the complex who live in the unit above the witness also smoked and were smoking inside. There was no evidence to provide that the unit in the rental complex shared a common ventilation system, and equally important that the witness's unit does not share a ventilation system with that tenant, or if it did, with the tenants on the second floor, again, the ones who also smoke. Lastly, neither party provided a copy of the lease or led evidence about the lease, which could have been written, oral, or implied. As such, it could not be determined that smoking was not permitted at all in the unit or in the complex. Since the only alleged behavioral issues took place during the notice period was smoking, and the landlord could not prove that in fact the tenant was smoking, the first N5 ought to have been by law considered void. For this reason, the landlord's application was dismissed. That wraps up the presentation portion of our webinar. As a reminder of all of the resources, we have our website at landlordselfhelp.com, where you can find our RTA fact sheets. We have sound advice podcasts, landlord learning modules, and landlord learning videos, specifically about N5 notices and filing L2 applications. We have our Facebook page. We have our YouTube channel where you'll be able to reach this webinar for replay, and we have our Instagram page.
Thank you, Ashley and Catherine, for your presentation. We will now go over the questions received during the presentation. So I'll start from the beginning. Somebody's asking if a tenant doesn't clean up the backyard after their dog and it affects the enjoyment of other tenants using it, can an N5 be issued? Ashley, can you please answer that?
Yeah, so that would definitely be a reason to issue an N5. If there are more specific details that you'd want to go into, I would advise seeking legal advice. But generally, having pet waste in a backyard that's interfering with other tenants would be a reason to serve an N5, yes.
Thank you. If the N5 is related to pets and the tenant has greater than the pets required by condo board, is the N5 a recourse for eviction in this case? Ashley, perhaps you can answer that.
Yeah. So if it's against the condo bylaws, then yes, you can definitely serve an N5 for interference. Um, you would list the specific bylaw that it's in breach of and the reason for serving the notice.
Thank you. Could an N5 be issued to a tenant who install a large swimming pool without the landlord's permission? There is no legal fence around it, takes up the backyard space with other tenants can use and enjoy. And he didn't ask for permission to use the water to fill it, which is the owner's cost. Catherine, would you like to answer that question?
Yes, so that would be an N5 for two reasons. One, it's interfering with the other tenant's ability to enjoy the common space. And another, it's against the landlord's interests and privileges, due to the high water costs caused from filling up a swimming pool. So that would be reason one under the N5.
Thank you. Somebody is asking about smoking. How do you prove this? How does one prove that the person continues to smoke? Catherine?
Yeah, I think the example that I gave in the Hain versus Minto case, they had great witness testimony when it came to the L2 hearing, not only the property manager, but other tenants. So if you have more than one unit and other tenants in the rental complex, witness testimony would be probably the strongest way to prove those allegations.
And meaning they would have to attend the hearing as well.
Yeah.
Okay, thank you. If the tenant is still in the unit and has been for the last 4 years, how old can our claim be for damages? For instance, a fridge drawers were broken over a year ago, and I'm requesting the tenant to replace or pay for them. Um, Ashley, can you answer that?
Yeah. So like Catherine said earlier, the key with damages is being able to prove that it was either willful or negligent. There's no specific limitation attached. However, I would caution that the older the damage is, the more evidence and proof that you're going to require in terms of negligent or willful damage.
Thank you. Can the tenant rent rooms out to others, use the living room as a bedroom? And would this be grounds for an N5? Catherine?
Yeah, so it's understood that tenants can, have guests, whether those be permanent roommates that from renting another room. In terms of using the living room as a bedroom, again, it comes back to what I was talking about overcrowding and the square footage and the space of your particular city's bylaws. That's, if you wanted to call our office, that may be something we could help you find. Otherwise, a simple Google search of occupancy standards bylaws with your city name would let you know if, the square footage of the living room would constitute as overcrowding. I think, as you could see by the three examples I gave, the threshold is very, very high to constitute as overcrowding. If it's one person sleeping in a living room, I would really doubt that it would meet that threshold.
And it would also have to be related to whether or not it's interfering with other tenants' enjoyment of the living room, because that could be a shared space, right?
Yeah, sorry, the way I interpreted the question wasn't like a making
Yeah,
sense. Yeah.
for specific situations, we encourage everyone to call our office and we will be happy to answer the questions because sometimes we need to ask more questions to get the details in order to provide you with accurate advice, which, of course, this is not legal advice. This is just for general information. So I'll just continue with the questions. My rental is a house and the tenant does not allow me in for inspections or to attend with a serviceman. He gives me a hard time every time I give notice and I'm not enjoying this rental and plan to sell. Would that be grounds for an N5? Ashley, can you answer that, please?
Yeah. So denial of entry after a proper lawful notice of entry has been served is definitely a reason to serve an N5. Like we discussed in the presentation, if it's a first N5, you would serve the notice and then try and enter again within a 7-day period. If they don't allow you to, then you can proceed to filing an L2 application.
Thank you. The next question says, what is cleanliness inspection? The tenant is a hoarder. Dogs have caused damage. Chewed doors. Catherine, can you please answer that?
Yeah. In terms of the question, what is a cleanliness inspection? There's nothing stated in the Residential Tenancies Act of what a cleanliness inspection is. What the Residential Tenancies Act gives the landlords the right to do is enter for inspections. So it would be up to the landlord within reason to go in and inspect the unit for cleanliness, which is an obligation the tenant has under the Residential Tenancies Act. If your situation is particularly dogs causing damage, that is something that you could put on an N5.
Yeah, and if the landlord wants to inspect the unit just for to identify any issues with maintenance or to identify any damages or repair, that can be included in just a general inspection. Okay. So, if we get a tenant that has a newborn, but the noise of crying is interfering with the other tenants, is this a reason to give notice N5? Ashley, can you answer that, please?
Yeah, so I'll just preface this by saying that I have a lot more questions that would arise out of this scenario. So if you're looking for advice, definitely call our office. But generally, no. A baby crying is not probably going to be deemed interference, depending on the setup of the property. It could also be a human rights code issue that we won't get into today. But if you're looking for information on that, definitely call our office and we're happy to expand further.
Thank you. Can you mail deliver the N5 and also email it without consent? Email being an extra measure, or do you always need email consent? Catherine, can you answer that, please?
Yeah, there's nothing that says if you don't have consent, you can't email it. It's just not going to be deemed proper service. So as long as there's proper service and you're only sending it via email as a backup, you're able to do that. There's no issues there.
Thank you. We had a tenant that got a black Labrador and the hair was clogging the laundry machine as well as it was getting into the other tenant's laundry, and we got complaints as well as the common areas were full of dog hair that the tenant didn't clean as per the lease agreement and pet agreement. Is this a reason to give an N5? Ashley, can you answer that, please?
Yes. So if the pet is causing interference with others and potentially even damage by clogging laundry machines, then generally, yes, you can serve an N5 for that. That would be considered interference or damage, depending on which issue you're wishing to pursue.
Thank you. The next one, it's I think three questions in one or a couple of questions in one. Does the accumulation of tenants' personal belongings stored in boxes stacked along interior walls and causing additional environmental concerns constitute overcrowding within the meaning of applicable housing or tenancy standards? Catherine, can you answer that?
No, overcrowding is specific to persons being in the rental unit, not objects.
Thanks. Does the placement of a mattress in the living room or family room of a two-bedroom rental unit, thereby accommodating two adult tenants and one minor child, constitute overcrowding under the municipal bylaws? Ashley, can you answer that?
So, like Catherine said earlier, it's going to be dependent on your specific municipal bylaw itself. Um, and it depends on if there's people in the two bedrooms and also in the living room. Like all of that would come into account, and you would need to discuss that further. But generally, I wouldn't say two adults and one minor child in a two-bedroom rental would be overcrowding. No, I don't think so.
Okay, and can persistent foul odors arising from uncleanliness, accumulated garbage, or similar conditions be considered damage to the rental unit, particularly where such odors interfere with third-party contractors or service personnel entering the premises and migrate into adjoining rental units? Catherine, can you answer that, please?
I wouldn't consider foul order like odors or uncleanliness damage. With damage, it really should be, here's a wall, here's the hole my tenant put in the wall. But un, you know, unwanted odors and cleanliness would be rather interference or for reasonable enjoyment of others or the landlord's lawful rights. So reason one, not two.
Thanks. What if it was partially voided? The tenant only fixed some of the issues and not the rest. The N5, in an attempt to avoid escalating to the L2B, can we continue with the L2 application? Ashley, can you answer that, please?
Yeah, so like I mentioned in the presentation, during the void period, you should keep evidence and a log of any behaviors or issues that continued. If you have continued issues or behaviors, then you can continue with the L2.
Thank you. Does the second and five have to be for the same behavior? Catherine, can you answer that, please?
Ooh, that's a question I'm gonna say call into the office. It's just too broad and would require more questions for towards your question, if that makes any sense.
Thanks. If a tenant can void first and five within 7 days, why the 20-day wait to file? Ashley, can you answer that?
Yeah. So the 20-day date is a termination date. What that essentially means is that the landlord tenant board wouldn't evict a tenant any sooner than that 20-day date, should it go to a hearing within that period. A landlord can file the L2 application after the voiding period is over. So after the 7 days, on the 8th day, if it hasn't been corrected, you can file the L2 at that date. The board just would not issue a termination order for any earlier than your termination date, which is the 20 days. And if you have more questions about that, feel free to call and I can expand.
If filed on L2 as the N5 was ignored, um it's either for to evict the tenant or to collect money, or can you do both? So yeah, I think what this person is asking is if the N5 was ignored and the L2 was filed, are you evicting and collecting the money, or what are you doing with L2? Catherine?
Yeah, the L2 is an application to evict a tenant and or collect money. So you could go to the L2 hearing and seek rather both the eviction and the repayment of the cost for damages. I hope that answers that question.
Thank you. Can I apply for an N5 when the tenant has caused bed bug infestation in their unit and the infestation has spread to other units and common areas? Can the landlord ask to collect the cost of hiring a pest control company to get rid of the bed bugs? Ashley, can you answer that, please?
Yes. So a landlord would not be able to serve an N5 for a tenant that has allegedly caused a bed bug infestation. The pest control company is the responsibility of the landlord. You wouldn't be able to pursue a tenant for that. The only time an N5 would apply to a pest control situation is if the tenant is not cooperating with getting the pest control sprays done, or anything surrounding that.
How should the N5 be used to deal with utility arrears that the tenant should have been paying as per the lease or a lease application, but have reverted to owner, thanks to the tenant changing account name? Catherine, can you answer that, please?
Yeah, so the N5, when it comes to utilities, you would select reason one as it's an interference with the landlord's lawful rights, interests, or privileges. And you would include as much detail as you could in rather the N5 box itself, attach a Schedule A with the information about the bills, the dates they were due, the amounts, etc.
What is the limitation period to use an N5 for damage? Between day of occurrence, which would be in some instances hard to determine for specific damage to, say, a window or giving notice. Damage often is still outstanding or not repaired by either party. So, Ashley, can you answer that, please?
Yeah, so there is no specific limitation period in terms of damages. If you have a specific scenario that you have in mind that you're looking for advice on, definitely call our office. It's kind of a broad answer, so I don't want to go too far into detail. Um, but you can still pursue the damages. You would just need the proof that it was willful or negligent and have all of that information available.
Is hoarding considered damages or interference? If interference, is it with enjoyment or lawful rights, privileges, and interests? Catherine, can you answer that, please?
I'm going to answer this question from with the expectation I'm assuming that this person is living in a unit by themselves. So hoarding isn't going to be an interference with reasonable enjoyment because it's their own stuff. It's not interfering with other tenants inside their unit. Um, Hoarding can be considered essentially a safety concern, but with hoarding, it's a very sensitive subject because oftentimes there's a human rights component that goes in with that type of behavior. So if it's a hoarding situation, I definitely recommend calling our office. For the purposes of today, I'm not going to expand on the human rights aspect of that answer.
Okay, thank you. Can I serve an N5 if the tenant ignored emails to enter the unit? Ashley, can you answer that?
Yeah, so if you have consent to email service and you served the notices of entry via email and the tenant refused entry, then yes, you can do an N5 for the denial of lawful entry.
Um, okay, so if a tenant allows their cat to roam the hallways and the cat is a carrier of bed bugs, can the landlord apply for an N5 so that the cat does not roam the public areas of the building? Catherine, can you answer that, please?
Yeah, that would be considered unreasonable enjoyment. Now, would that type of behavior be successful at an L2 hearing? It would depend on your witness testimony, I would say, and your ability to prove that the cat's spreading bed bugs. But certainly, it would be most fitted for an N5 notice.
Thank you. Can an N5 be served for tenant adding AC in their unit? Ashley, can you answer that, please?
Yeah, so not generally. There would have to be a specific interference or damage that installing the AC has caused.
Okay. If the tenant is using a parking garage as a storage and not for parking the car, can an N5 be issued? Catherine, can you answer that, please?
Um, I mean, if the garage is something that's included in their lease and they're using it as storage for belongings, not a car, I would say that's, quite reasonable use of the space, and an N5 probably isn't going to be successful in that. If there's, again, I have more questions. What are they storing? Is what they're storing causing a safety issue, et cetera, et cetera. So if you want more details, call into the office. But generally, landlords should be cautious of, if the behavior that they don't like coming from their tenant is something reasonable. It's a reasonable level of noise, reasonable use of the space, et cetera.
Thank you. So in the case study in the presentation that the tenant was smoking inside, how can the landlord provide the evidence of the tenant smoking inside the unit? I think it's challenging to prove that he breached the conditional order in such case. What kind of evidence should be provided besides the neighbor testifying as witness? Ashley, can you answer that, please?
Yeah, so it definitely is challenging. Witnesses are great. The other thing to keep in mind is keeping a date and time log and the specifics, and having a copy of the lease, which if the lease says that whether it's a building that permits smoking or it's a non-smoking unit, that's important as well. And like Catherine said, that case had specific details around the sharing of um, like vents and ducts and how smoke would travel between units. So you would need to be mindful of that as well. But the best way is to just gather as much evidence and witnesses as you can.
Okay. If a tenant is complaining about another tenant's behavior interfering with a reasonable enjoyment of their home, but the tenant who complains does not agree to be a witness in court, is there anything a landlord can do? Catherine, can you answer that, please?
Witness testimony isn't the only form of evidence. In my opinion, it's often the strongest. Um, if your tenant is keeping logs of the interference, that's also going to be very, very helpful. Um, again, I mean, I don't know exactly the allegations or, can predict the outcome of cases, but it's not a requirement that a tenant comes forth as a witness. It's just, recommended as the best form of evidence, but other things like logs or pictures or videos or emails could also be used.
Thank you. If the behavior that prompt an N5 is related to mental health challenges, is there anything we need to keep in mind about the Ontario Human Rights Code? Any general comments are appreciated. Ashley, can you answer that, please?
Yeah. So very generally, a landlord does have a duty to accommodate up to the point of undue hardship, and the undue hardship threshold is quite high. Each accommodation would be individual, and it would have to be done with the tenant. So the landlord and the tenant should work together to try and meet any accommodation needs.
Thank you. Okay. We're just gonna do one more question in terms of the time. We have reached an hour. If a tenant is in the unit for 6 years, the walls have holes, broken closets in the rooms, will that be wear and tear? Catherine, can you answer that, please?
Yeah, I think I'll comment back to the case that I discussed. I think one of the biggest reasons the landlord was unsuccessful at claiming that this was damages versus wear and tear is they had no pictures of the unit beforehand. So, if you have pictures of these closet doors perfectly intact and then you discover they're like hanging off the walls, I wouldn't consider regular use of opening and closing a closet door over 6 years as a threshold of normal, I would consider that natural use, right? Not something that would cause the door to fall off. It's a very specific incident, but I think when it comes to landlords trying to make the argument that something is damage versus wear and tear, it's important that they know that the onus is on them to do it. So pictures of things before and after can be very, very important. And also that, your ability to kind of prove that it was something that went beyond the normal use of whatever you're alleging to be damaged.
Thank you so much, Ashley and Catherine, for answering the questions and presenting today's webinar. For everyone else's questions that we couldn't get to, we strongly encouraged you to call our office. We'll be open tomorrow at 9 a.m. As well. If you're not able to get through the lines, we're a small team. There's 4 full-time community legal workers answering phones and as well receiving walk-ins. So if you're not able to get through, you can email with your phone number and somebody can call you back or just keep trying. But yeah, we have some information on the screen right now about our upcoming landlord learning forum, which is going to be on November 20th. That's in person and it's free. So yeah, there will be more details about this event by email. So ensure that you're subscribed in order to receive information about this event. It will be in Toronto. It will have a presentation portion, which will be recorded as well. And lastly, our survey. Your feedback is very important and valuable to us, so please take a moment to fill it out and let us know how we did today. So thank you so much for watching, and we'll see you next year for new webinars. Bye, everyone.
Thank you, everybody.
Thank you.